Welcome to yet another edition of latest legal updates. In this session, we make an honest attempt to analyze latest judgments that have been passed of late. For today's topic of learning, we analyze the latest legal judgment passed by the Delhi High Court on 10th of July 2020. In this judgment, the Delhi High Court rejected the statutory bail application of Sharjeel Imam. We'll look into the brief facts of the case, look into the points of contentions, look into the bigger issues that could be raised or could be classified, and finally we make an attempt to give you the judgment and analyze it thoroughly via certain conclusions from our end. The facts of the case are really simple. Sharjeel Imam is a student of JNU who was on the forefront of the protests that happened pertaining to the NRC and CAA. There are videos of him addressing a huge chunk of the population at the masses, at JNU, and at the Aligarh Muslim universities, and at various locations. Multiple FIRs were filed against him, and he was arrested on 28th of January in Bihar. He was arrested under the section 153A of the IPC, section 124A of the IPC, and section 505 of the IPC. Section 153A is, of course, on promoting enmity between various groups or classes of society. Section 124A is on sedition. Section 505 is on statement conducive for public mischief. Sharjeel Imam, after being arrested, was kept in police custody, where the police was investigating the entire process and the entire case. The investigation time was, of course, 90 days because of the section that would have been imposed. Now 90 days is, of course, the time given as per 167th section of the CRPC, clause 2 to be precise. Now this entire 90-day investigation process was the time in which he had to be in custody. But on the 88th day, the Delhi police also stated that we have to ask for an extension of this investigation process, because there are also provisions of the UAPA, that is of course the Unlawful Activities Prevention Act. Various provisions of the UAPA are to be imposed against Sharjeel Imam, and the UAPA allows to extend investigation process, and which also means allows to extend the to have an individual in custody from 90 days to 180 days, as in another 90 days, totally making it 180 days. Now, Sharjeel Imam was totally against this entire thing, because as per him, there were various discrepancies in this entire process of extending and imposing provisions of the UAPA at the 88th day, at such a later stage of investigation. And therefore he went to the Delhi High Court asking for a statutory bail, which is granted, sort of a bail that is granted to everyone after the investigation time is finished. Now, since an extension was also asked by the Delhi police for investigation, the Delhi High Court, the Delhi Patiala House Court, which is of course a trial court, stated that will allow an extension and will deny the statutory bail application, because it is imperative to first complete the entire investigation process. That is the only time, and that is the only process post which we move to any proceedings of the case. Sharjeel Imam was vehemently against this entire judgment, went to the Delhi High Court, and Delhi High Court reiterated what the trial court stated, and judgment came on 10th of July. Now let us understand what were the contentions that were there. Now, contentions were really simple. Sharjeel Imam stated that the UAP which was being invoked was invoked at the 11th hour on the 88th day, and which of course this entire discrepancy in this entire sort of politics of imposing it on the 88th day is basically to deny him of any form of bail. It is also contended by the counsel and by Imam that invocation of the UAPA is at the 88th day of custody is solely intended to curtail him of any rights that are granted in the constitution, rights which allow him to have liberty, and this imposition or this this extension curtails him of right to liberty and various rights are granted him under the constitution. Now, the legality of this entire argumentation was on the grounds that there are various essential requirements under the UAPA that are to be fulfilled. Specifically to talk about section 43D, section 43D, subclause 2 of the UAPA. And this entire legal debate was also brought about of how the UAPA was imposed. Now, but the IO and the investigation officer was very simple and blatant on the grounds for investigation and the grounds for an extension. They stated that since a lockdown was imposed in Delhi and all over India, that hindered the entire investigation process, and they could not investigate the matter properly. Of course, this is a valid argument because till the time you don't have an investigation, you cannot move forward with any process of a criminal nature, and investigation is the preliminary stage of looking into criminal matter. Delhi High Court was totally in favor of this. So was the Patiala House Court. What is the bigger issue here? What is the exact argument, or what is the exact question of law here? The question of law here is that at one case we do allow statutory bail post 90 days, and in a special circumstance of the UAPA we allow extension. But if this extension is asked at something like the 88th day or the end of the custody period, is it right? Another question of law. Is it right to ask for such extension on a ground like hindering of investigation process due to lockdown? Can the COVID pandemic be a valid reason for asking for such an extension? Now, the judgment given by the Honorable Judge of the Delhi High Court was pretty simple and were on the lines of the judgment given by the Patiala House Court. Of course, they replied to various legal debates and legal questions and discrepancies of law, but the main thing which they reiterated was that the prosecution has already given grounds for extension of time. There was an entire report given by the additional public prosecutor. The 25th March lockdown was a hindering process for any profession and for any work that is happening in our country, and that could be a valid reason for hindering any process of the Delhi police. And if we are not able to get some sort of an investigation in the preliminary stage, how could we move forward? And since this is a valid reason for multiple professions, why could it not be for investigation? And the global COVID-19 pandemic was taken seriously to disrupt the investigation. And they even stated that the trial court, while granting the extension of the investigation, was satisfied with the application of report of the prosecutor. And similarly, even the Delhi High Court is satisfied. Now, what is this entire issue? What are to be concluded here? Of late, we've seen number of cases wherein the COVID pandemic is being debated in law in cases. Now, it is valid to some extent to curtail certain provisions of law in such extreme circumstances like the COVID-19 pandemic, and that is the entire reason why the Honorable Judge Mr. Justice V. Kameshwar Rao has reiterated this. Of course, certain valid arguments were raised by Rebecca John, who is the senior advocate who is representing Sharjeel Imam, but this could still not stop the Delhi High Court from allowing an extension to the investigation. That's about it. The entire semantics of the judgment rely upon the COVID-19 pandemic. Even though imposing in this extension or the 11th hour could raise certain subjectivity, but it is imperative to consider the COVID-19 pandemic as a definite reason for disturbing investigation process and a various process of law or other issues. Thank you so much.